The second case on this morning's docket, case number 117347, State of Kansas v. Andrew M. Woodring.
May it please the court, Kristen Patty for the appellant Andrew Woodring. Your Honor, may I have 3 minutes for rebuttal?
3 minutes is granted.
Okay, thank you. I know with your preparation for both Mr. Gentry's case and Mr. Palacio's case, you're very familiar with the overall facts of this case. Mr. Woodring is one of the co-defendants from this same incident. And as I understand it, the state's theory regarding his involvement was that he introduced Mr. Palacio into the situation and that he acquired the vehicle and that he was the driver. Mr. Woodring did not have a trial. He went ahead and entered a plea to felony murder, got the hard 25 sentence, when had dismissal of the other counts that he was charged with. But between his plea date and his sentencing, he filed a pro se motion to withdraw that plea. And the court held a hearing, and eventually Judge Young, I've seen this in other cases, Judge Young often likes to take something under advisement and then come back and give a ruling on the record, and that's what she did. And she denied the motion to withdraw the plea. And that's the focus of Mr. Woodring's appeal, is whether in the pre-sentence context, whether he established good cause for the withdrawal of his plea. Here, his trial was scheduled to start just right on the heels of, I assume it was Mr. Gentry's. I realize I probably should have looked last night. They were basically going to go back to back. And so, of course, part of his concern was the pretrial publicity, not only through the newspaper or maybe television, but also the just social media aspect of that. He was also concerned about a body cam video of one of the officers that showed the victim, Ali Sam, laying on the ground, and the effect that that would have on his trial. And he felt pressured by the prosecutor, Ms. Trocek, to enter a plea by a specific deadline. And those are all the things that he testified to as part of his motion to withdraw his plea. Of course, under the Edgar factors, there are a number of things that the court can consider. And I'm sure Ms. Mitchell will get up here and remind you of these as well. Was he represented by competent counsel? He did not argue that his counsel was ineffective in any way. The plea hearing, the colloquy that Judge Young went through with him was thorough. So the real issue is whether he was coerced and whether the fact that there was a deadline and just, as I said, the temporal facts of his case coming right on the heels of the trial of another one, and whether his jurors would be influenced, not knowing that this is the case that they were called for, whether his jurors would be influenced for something that happened just the week before. And that's primarily what he argued.
Say that again, that his jurors would be impacted by what happened a week before the trial, the other trial?
Sure. I mean, if you could call...
First of all, let me understand the timeline. The timeline was that he was given this offer and 10 days, something like that,
yes,
to make a determination as to whether he wanted to accept the plea. He indicated that he had time to discuss that with his attorney during that 10-day period. What kind of timeline would you say would be outside of the not being coercive? 10 days seems like, at least in my mind, not doesn't seem to be unduly coercive or pressure. That seems to be allow for a lot of time to reflect and discuss.
And I can see that the court may make that determination. I think that it's not in so much the 10 days as the timing of his trial, like I said, just right on the heels of his co-defendants.
So that doesn't have anything to do with the DA. So now, I mean, you mentioned two things that were coercive. One was the DA, one was the back-to-back trial.
Right.
Now you're telling us the 10-day thing isn't that big a deal. So now we're down to the back-to-back trials was somehow putting pressure on him, correct?
I think that's probably more the focus, and then of course, yes, the other problem that I have, and as you know, I have to argue the record that I'm given, is that there did not seem to be any direct contact between Ms. Trocheck and Mr. Woodring. It was an email that his trial counsel showed him where she had placed a deadline of him accepting the plea that he argued was coercive.
That seems a little more remote. Let me move you over to what's our standard of review.
The standard of review is abuse of discretion.
So how would no reasonable person have rejected the motion to withdraw the plea under the circumstances that you're citing?
Well, I suppose that it's just whether all the circumstances together come together to make good cause. And while we have the 3 Edgar factors, it's a non-exclusive list, and certainly the court can consider other ones, and it's not like he has to establish all of them. In some ways, I suppose, what if the judge thinks that something is a good reason, is enough to have his plea withdrawn. And here said it was was the back-to-back trials that could have unduly influenced the jurors for his trial if they'd been paying attention to the trial of his co-defendant.
What would be your argument if he was tried along with the others? Isn't that even worse than having a trial the week after one of the co-defendants?
It could be, since he didn't have a trial, and I'm not completely privy to all the information that was introduced in his co-defendants' trials. I did look online and see some of the news coverage, at least myself. So I don't know what effect, for example, co-defendants' statements coming in could have been a problem. I'm not sure why the state decided to, whether they decided, could have tried them all together, and then of course said they all got separate trials. So no, I'm not sure.
Do you have any further presentation?
No, I do not, Your Honor. I'll save any other comments for rebuttal.
Do we have any further questions?
Just one quick one. The shooting occurred like the first week of May in 2015, and it appears to me that just right at 11 months later, the state made a plea offer. Was he represented by counsel during that whole time?
Yes, he was, and part of it is...
Does that factor into our calculus as to whether this is a time pressure? It would seem to me that if you've got nearly a year being represented by counsel, that the concept of plea negotiations would have been discussed, and it shouldn't be something that falls out of the sky.
Well, and I have to admit, I didn't, maybe I should have looked this up last night, and I didn't. I don't know whether it was the same attorney throughout.
Okay.
There was a little bit of a problem that initially, when this incident happened, Mr. Woodring was still 17 years old. which meant, of course, that he needed to be charged as a juvenile and certified as an adult. And whether, believe it was Joseph Allen, represented him at this, when he entered his plea, whether Mr. Allen had represented him from day one, I don't remember right off the top of my head. But he would have certainly at least have had an attorney through the juvenile process.
Any more questions? Thank you, counsel.
Thank you.
Please the court, Ellen Mitchell, Saline County Attorney on behalf of the state of Kansas, the appellee. I don't have a lot of argument in this case. I think it's pretty clear that the court considers the Edgar factors, but is not limited to those. In this case, Mr. Woodring clearly just had a case of cold feet, the state contends. He was satisfied with the representation of his counsel. As indicated, the case had been pending almost 11 months. Certainly, competent counsel discusses with their client the charges, the penalties, the potential outcome of the case, and apparently he did, because Mr. Woodring said he was afraid that he was going to get convicted of everything, and he knew what that penalty was going to be, and that's why he accepted an offer. The offer originally was that he enter a plea before the verdict in the first co-defendant's trial, simply just so that you don't have the advantage of going last or after the first. Everyone had an offer. If you didn't want it, it went to trial, but we didn't want to give the others the benefit of seeing what happened in the first trial, and that's where it was. But she changed that, and
in that regard, the offer was in April and the motion was June 6th. How did that fit? Had all the trials been completed by the time we had the pro se motion to withdraw?
I believe Woodring, only 2 went to trial. Sims, Forbes pled, and Woodring was the last to be resolved, is my recollection. Sims may not have entered his plea, but Sims entered into an agreement to testify, and so his case was resolved as far as what was going to happen. The plea offer was extended past the time of the verdict until the following Monday, I believe. He
would have known that Gentry, by the time we have a motion to withdraw, he would have known that Gentry was convicted of felony murder?
Yes.
The same thing he had pled to?
Yes.
Okay.
The jury selection, the argument that, the prior defendant would have been just convicted a week or 2 or had his case resolved a week or 2, but that would have happened during jury selection. That would have been discussed. We try to use pretrial questionnaires only in homicide cases, but ask about pretrial publicity there first. And then we do it again. We sometimes just bring in panels. We don't want one juror to taint our entire jury panel. And so questions, if someone has a response that we feel that might happen, then we step outside into the judge's chambers so that person can make their statement, but the other jurors don't hear. So we would have determined if selecting a jury who was impartial, we would have done that during jury selection, and it wasn't a problem. But if it would have become a problem because he would have been the 3rd case to go to trial, then we would have stopped and reconsidered any motions to change venue, that sort of thing. That didn't happen in this case. Really, Mr. Woodring doesn't give any legally valid reason for wanting to withdraw his plea. There has to be some benefit in finality. He came in, he signed a written waiver, he answered all the judge's questions, and the state also contends that setting a deadline to accept an offer is not coercive. It gives you reasonable time to meet with your counsel. It saves court time. We set these cases, 5 of them, back to back. It was gonna, allot 2 weeks for each one, almost. That's a lot of court time, and that's a lot of preparation time, and it's reasonable for the prosecution to set a deadline to accept that offer, and we believe that's what happened in this case.
Any further presentation?
No.
Any more
Thank you.
questions? Thank you, counsel.
I don't know that I have any further comments to make on rebuttal, unless there are any further questions for me.
Any more questions? I see none. Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement this time.